Hello, I'm Anthea Hancox, the CEO of the Scanlon Foundation Research Institute, and we are delighted to bring you this special limited series of our Voices of Australia podcasts. As always, this podcast was recorded on the land of the Kulin Nation's Wurundjeri people, and we pay our deepest respects to elders past and present. I'm welcoming you to the Scanlon Foundation Research Institute's new 6-part limited podcast series, Truth, Trust and Politics, a podcast that explores the complexities of truth, trust and political communication as we approach the 2025 federal election campaign. From mistruths and manipulative tactics to the erosion of trust in political communication, this series unpacks the dynamics that shape modern politics. We'll ask critical questions: who stands to gain from misinformation? Who's most vulnerable to its influence? And most importantly, what can we do to clean up our discourse and rebuild trust in our democratic processes? Featuring community thought leaders, politicians and policymakers, journalists and researchers, we'll explore the role of truth in shaping voter perceptions, the impact of social media, and strategies to counter the growing influence of mistruths. Join our guest host, Mary Gearan, award-winning journalist, MC and facilitator, as we examine how misinformation and the decay of trust impacts social cohesion, who it affects most, and what we can do to foster a healthier, more informed democracy. Mary's guests for this episode are Zali Steggall, Independent Federal MP for Warringah, and Michael Maley, former senior official at the Australian Electoral Commission, who's worked internationally on election design and administration. They'll explore the potential benefits and challenges truth in political advertising laws would have in countering misinformation on the political stage.
Zali and Mike, thank you for joining me. Let's start with, I don't know, it's an easy question or not, truth. It should be an easy thing to define, but it isn't. Why isn't it, Zali?
Well, I guess it's first we've got to understand what is truth, right? Ultimately, truth is a question of fact. And if I think of it from a point of view of with my barrister hat on, for example, in a court case, you will have both parties in a litigation will put forward their version of events, and then a judge will determine who is the most credible witness, and so whose facts and versions of events is to be believed in that court case. So I guess that's what I would sort of bring back the concept of truth to, which is a credible set of facts in relation to an issue. And again, it's something that has been the subject of litigation and determination by courts and judges since we've had a justice system.
Mike, that seems pretty straightforward, does it?
Yeah, I think so. And it ties in with what the philosophers used to call a correspondence theory of truth. And I suppose from a philosophical point of view, you may well have competing concepts which aren't necessarily all that relevant here, such as biblical truth, where, that which is to be factual is handed down through some sort of religious text or something like that. But broadly speaking, in a political context, I'd have thought what Zali had to say would be pretty generally accepted.
Yeah. And I think it's important when people get really worried about this, yet they accept that truth or truth in relation to facts is something that is determined all the time. And they then think about it as, is it freedom of speech and is it opinion? No, you can still have opinions that differ from the facts, in your opinion. But when it comes down to who is the arbiter of facts, like if there is a litigation and a dispute, it comes back down to our court system. And we've always had that pillar of justice separate from government that exercises that really important role of, I guess, determining disputes when there is disagreement. And I don't see how when it comes to this issue around facts, when we put them into the public domain by publication, especially through advertising, that should not be any different. And I know we're probably going to get onto it, but we accept that there is such a thing as true facts when it comes to consumer products, right? We accept through tort law and our consumer law that there are certain, representations that you make on behalf of something, a product you sell or a service you provide, that has to be factually correct, or there are consequences. So we're really not, and so that is a concept of truth as well, right? The truth of what a product may or may not do.
Part of the problem is you have a pre-existing product and you can test whether it does what it says it's going to do, whereas often in political context, you're talking about policies for the future and events which are going to unfold in the future. So if you get into a debate about, say, the cost of nuclear energy or the safety of nuclear energy, or where climate change is taking us 10 years, 20 years, 30 years down the track, then you are getting away from something which you can test objectively in the same way, and you're getting into arguments about probabilistic modelling, and even the climate scientists would tell you that there is going to be a level of uncertainty around their projections because that's inherent in the nature of that sort of science. So I think that's where it starts getting difficult, because so much political debate is in fact about what's going to be happening in the future and what are going to be the implications of that. And that's where it becomes a challenge.
So before we get into, we will get into, Zali, how you think that can be solved and what can be actionable under legislation, for instance, that you have been promoting as well. But I guess just to draw it back to that more philosophical issue around politics at the moment, you were saying there are accepted facts, Zali, in certain parts of our life, but in politics, as we know, a certain Trump person introduced the term alternate facts. It's different in politics this time. It's gone from a contest of ideas and policies to a contest of facts, of worldviews, of tribal identities. How do you cope with that? Before we get into the syntax of how you might address it in legislation.
Yeah, well, I actually, a term that that I sort of like to use is actually, some people are fact resistant, right? Because basically they don't like, and so they look for alternate facts.
But fact itself has become some sort of
like this is something
cultural war ground.
Well, or like the idea that a fact is discretionary. It's not, right? And the idea that they're fact resistant. I mean, if I think of Trumpian politics, where they just put out a completely alternate version of events or of facts, and it reminds me, going back to high school, where actually one of the books I studied was Sophie's Choice. And that is all about the philosophical aspect of, is the world as we know it, or is there an alternate reality really happening and we're all being fooled into thinking this is the reality? And that's nearly what Trumpian politics is doing, is this idea that challenging the sort of the set of facts that are accepted as being the basis of our reality, into a suggestion that there's something completely different out there. There's a completely different version of events. And if you say it often enough and with a straight enough face, somehow that's going to, it sort of settles, which really takes us into philosophical and a whole other kind of concepts, which in all it serves, I think, is to confuse, to redirect and misinform people, because I think at the base of it, most people accept the ordinary set of facts of the world of reality that we live in.
Yeah.
It's worth making the point that this isn't a new phenomenon, though it's very much more in our face these days. There have always been Holocaust deniers. There's been an argument for 70 or 80 years about whether it was necessary to drop the atomic bomb in order to end the Second World War. These are the sorts of arguments that are going to go on, where information is not necessarily complete or generally available to everybody, or it may not be available for 30 years if you're waiting for government records. These are complexities which are part of the human condition of interpretation of history and the like as well.
Well, I think there's always been conspiracy theorists, like
Yeah,
people that say we never, the American didn't walk on the moon. That the whole thing was put in a, was a setup, or that deny things. But it's quite interesting in a world where everything is evidenced by video. Like, we have so much now that is recorded, but then recordings can be manipulated, right? So
mm,
unless you're seeing something that is live, and then there's always a question of perspective. So look, we can enter into a very long philosophical discussion if we really go down this rabbit hole.
yeah,
Well, indeed. I mean, it's actually a good point potentially to go back to, Mike, your history with truth and political advertising laws. You were, as a young bloke, first drafting this back in 1984, and those laws didn't go too well. And in the end, facing some of these philosophical problems and practical problems that are brought up and thrown in the faces of people like Zali today, can you take us through what happened with those ill-fated laws in 1983, 1984?
sure. Well, you really have to go back to a case in the High Court after the 1980 election, Evans and Crichton Brown, which was actually three cases heard together, one about the Senate election in Western Australia and then a couple of House elections, where the High Court had a look at the provision in the Commonwealth Electoral Act, which prescribed false information in relation to the casting of a vote. And they read that down to mean really the mechanism for recording the preference you have already arrived at, rather than material which might be misleading in relation to your process of arriving at your preference in the first place. So that was then identified as a gap in the Electoral Act, and I think it became Labor policy, in fact, to fill the gap. When the Hawke government came to power, they set up the Joint Select Committee on Electoral Reform, which did a comprehensive review of the old Act as it stood. But they didn't really get into truth in advertising, partly because it wasn't as big an issue then as some other issues which were really prominent, like redistribution and the like. But also, I think it just got left. And so when the drafting was being done for the Commonwealth Electoral Legislation Amendment Act 1983, which gave effect to all of the recommendations of the committee, we had to find a model for a truth in advertising provision. And oddly enough, there's a reference in Billy Hughes's biography by Laurie Fitzharding to the regulation which he put in place immediately before the second conscription referendum in 1917, which was a truth in advertising provision. And so having read that, I trotted over to the law library at ANU and tracked down the old regulation and attached that to the drafting instructions, which went to Office of Parliamentary Counsel. So what was in the ultimately in the bill very much reflected what had been done in 1917, when it was probably drafted by Sir Robert Garran, as it happens. After that, the committee sort of started to pay a bit of attention, and they got very nervous about it. And they issued a second report after some fairly lengthy inquiries, which raised a lot of their concerns about how the provision might operate. And the long and the short of it was that there was a agreement among the major parties, with only Senator Michael Macklin from the Democrats dissenting, that the provision should be repealed. And in fact, next Friday is the 40th anniversary of that repeal. And that's where it went. Now, the report is quite an interesting one, because they had evidence given, for example, by Michael McHugh QC, who later became a High Court judge. And he tended to highlight more the complexities of distinguishing between predictions, opinions, and statements of fact. The Attorney General's Department, in their evidence, were really less concerned about that. They thought that the distinctions were rather more clear-cut. But McHugh was pointing to various legal precedents which said, for example, that a statement of opinion could imply inherently a statement of fact, and therefore be treated as a statement of fact as well. So it all got too complicated, and frankly, I think the major parties decided it was going to cramp their style. and so that's where it went.
Well,
But that report is actually still worth reading because it goes into some of these philosophical and legal issues in a lot of detail. Having said that, it's 40 years old now, and the law has evolved, and the common law has probably evolved as well.
well, that's a good point. 40 years have passed, and the world's much more complicated. So, Zali, if laws couldn't get up then, how do they get up now with this far more complicated, truthiness world?
Well, I think they're actually more important now than ever because the way in which information is published and disseminated has changed dramatically in 40 years. And it is incredibly powerful. And we don't have some of the protections that were still inherent in the system in terms of, I guess, how, what use people made of information, especially political parties, how they would, there was a bit more care or concern for reputational damage, maybe, about openly lying. That seems to be dissipating now. And as we see people fact resistant, alternate versions, people are quite happy to go out there, and political leaders, I think, repeating a fallacy, thinking that if we repeat it often enough, it becomes fact. And unfortunately, media all too often reports a position as a matter of fact rather than an opinion or allegation. And that is really concerning. So I think it is needed more than ever now because things are presented to a voter, to the public, as a matter of accepted, proven fact when they're not. And so you can, if a politician wants to put forward a position on, like Michael referred to, like climate or predictions or things like that, you can express it as an opinion, but you can't say it is a verified fact that this is what's going to happen. And that's true on all sides, right? So I do think it's important now more than ever to legislate. I'm not naive in thinking it's perfect. At the moment, we're in a situation where we have no guardrails, right? When it comes to messaging, paid advertising, stuff that gets pushed out to particular audiences through social media and online platforms, there is no guardrail around what can be said, which means we have a situation of complete mistrust by the public of any information provided. There's, a high level of skepticism. And then there is also the problem of misinformation and then disinformation, which is a more purposeful step towards misinformation, right? And so we do need to put the guardrails up. Will the guardrails be perfect? Probably not, but that doesn't mean we can't get some guardrails up and then adjust them through processes of review if that's what's needed. That's the process most laws go through. They are not perfect the first time they go up, and they do need adjusting. And I think this is a classic case where we have people saying, well, it's too hard, or raising concerns. I think we need to really think about the consequences of not having guardrails.
Mm. Mike, would you agree with that? And this is, after all, this narrow focus that's constitutional and enforceable, as they say about the South Australian laws. Why isn't that applicable on the federal stage?
We're looking at in many ways a wicked problem, and I don't disagree with anything that Zali has said about the nature of the lack of guardrails at the moment. It really is from a democratic point of view, it's extremely disconcerting to see how much false information is out there with impunity. At the same time, the context has changed even in the last 40 years and beyond recognition since 1917. Even back in 1984, campaigning was primarily done through very narrow mechanisms, through radio, through television. Public meetings had sort of gone away by then. Printed advertising, stuff done by printers. So the number of players who were directly involved in disseminating information was relatively limited. Now with social media, basically you've got point-to-point misinformation flying around. You've got stuff which can be put out through websites that are hosted outside the country, through services that are provided from outside the country, which gives rise to issues of extraterritorial enforcement of laws. So that makes it very difficult to deal with. And
But how would you deal with that, Zali?
But well, I think we have to start by legislating voter protection laws, and that's why, from my point of view, is I don't think we need to reinvent the wheel. I think it is about mirroring a legislation that has been shown to be not 100% effective, but a deterrent. Remembering the point of laws, right, is ideally to catch wrongdoing and bad conduct. But ultimately, our whole system is predicated on the idea of deterrence, right? We are a system, we have laws to deter the vast majority of the population from breaking those laws because of the fear of the consequences. There will always be bad actors that will break the laws, and then you test how good the system is in whether or not they catch them. And that's the same for hardcore criminals, to liars, to everything else. So the question is, I think we need to bring politics into line with other areas like consumer law. Like it's quite, I think, incredible to suggest the double standard we're allowing for at the moment in our system, which is where we say to Australian people, we're going to protect you from scams, for example, right? You can't be scammed out of your money if you're buying a vacuum cleaner if it doesn't do what it's going to do, but we can scam you out of your vote. That's not a problem. So we accept that we protect consumers when it comes to their consumer rights. I think we just need to look at political messaging and advertising in that same lens of being, we need to protect voters and their voting rights so that they can exercise it with reliable facts. There will be differences of opinion. There's no doubt about that. This is not about restricting speech, but it is about equipping voters with the facts. And that is also, I mean, when we talk about medium changes, we now have AI and deep fakes, right? We still don't even require the identification of where AI is used, or, for example, where something might be a deep fake. And I think consumer law is going to head that way. I think it's only a matter of time that in consumer law and consumer advertising, you are going to have to disclose, for example, is that a real person or is that an AI generated person in that advertising, right? We know that's already happening. And there are real questions, ethical questions around, to protect a consumer, for a consumer to be fully equipped, they should be made aware where this is a real person or is this an AI generated person selling you the product, right? Or how clothes might look or something like that. Voters, I think, are entitled to that same level of disclosure about what's being presented to them, and they then can make up their mind. And so that's what we're talking about, I think, through what I'm proposing around voter protections is more fulsome disclosure of what is being put forward so that a voter can either choose to accept the facts or not, but is equipped with the full disclosure of what's being put to them.
Mm.
I'd certainly agree with Zali's point about having a requirement for AI-generated material to be identified as such. I think that's a no-brainer, and it actually should be relatively easy to enforce compared with some of these other issues. As far as deterrence is concerned, I would agree, but I think what one then needs to do is drill down into who is being deterred and what sort of things would deter them.
You're saying that the shame of being labelled someone who propagates mistruth just doesn't have the same ring anymore, not in 2025.
That's true. And thinking about some of these issues and how things have changed over the last 40 years, you're really looking at a cultural change in Australian politics from, and again, when I think back to the Select Committee on Electoral Reform, one of the key players in that was John Carrick, and he was part of that generation of people who'd served in the Second World War. He'd been a prisoner of war in Changi. He was a distinguished statesman, and he had an experience of serving the country in a context that went beyond party. And increasingly, what I think we've seen in Australian politics over the years is the growth of a political insider generation, to whom, in many ways, the independents are a reaction on the part of the public, that they don't like what they've been seeing in the major parties, where you have people who basically go from being student politicians to being staffers to being pre-selected. and that is not a good context in which to incubate the right sorts of ethical approach to politics. And personally, I blame the Members of Parliament Staff Act for that, among other things, that it creates that sustains that insider class. But that having been changed, you then have to say, well, if these are the sorts of people we're dealing with, what's going to frighten them? The prospect of a $2,000 fine, and some brief mention in the paper from a magistrate's court isn't going to worry you if you think it's going to win an election. You have to come up with penalties and sanctions which are really career-ending.
Okay, let's skip ahead to penalties then.
Yeah.
What do you think should happen?
Well, I think you should have a situation where these things are determined by the court, but if there's a finding of serious deliberate misinformation, which is the sort of thing a court could be required to rule upon one way or the other. I think you should be looking at disqualifications from being a candidate, disqualifications from being a member of parliament, maybe disqualifications from having any sort of Commonwealth or state funded employment. There's already provisions in the Electoral Act which disqualify you from being a candidate if you're convicted of bribery. So it becomes a question of whether you're prepared to take that further. I think that would work, but I'm not at all convinced that the parties would be prepared to come at it. But it's got to be something that really concentrates your mind all the time when you are putting material together, saying, could I get caught in the trap? And if it's just sort of, oh, well, I'll get a fine, someone else will pay it from the party funds, it's not going to hurt my career. It's not going to constrain my ambitions. That's nothing. Those sorts of things are not deterrents. I think you've got to go for something really vicious and brutal in terms of the cost to your political career. It should be career ending.
Zali, how vicious and brutal do we need to be?
I don't disagree in principle. The reality, having sat in Parliament now for 5 years, there are so many things I've seen that should be career ending that I think that's look, I think the question of the penalties is something, but ultimately that is something that can be reviewed. So if it's found that, for example, the stick is not deterring enough, that can be tightened up. So I think it's concern about whether the stick is hard enough, like the penalties are bad enough, should not be what stops us from putting the guardrails in place. I guess I would also compare it a little bit. I think, again, the consequences are important. I think what's interesting, and I've sat down with ACMA, for example, and the commercial side, right? If I look at what happens in commercial advertising, they have an independent body funded by the industry, so it's not government funded, but they are a self-regulated industry in a sense. And there are consequences. So where the industry funds the body that then independently reviews complaints around consumer advertising, and either stops it from being aired or requires corrections and things like that. And then obviously there's always the final resort to the courts if you've got a consumer complaint. But what that allows for is, because publishers are also at risk, right? There's reputational damage as well for publishers if they are putting forward advertising that is ultimately found to be misleading and deceptive. And so they also have an interest in having this kind of independent board that reviews and makes sure it ticks all the boxes. And they have voluntary codes of conduct when it comes to content, that it has to be appropriate when it comes to gender content, or can't be discriminatory. And this is ongoing and evolving. So I do look at that sort of the deterrence within the commercial industry of how that works. And obviously ad agencies, for example, if they continually come up with content that is against the rules, that becomes a reputational damage for them as well. So it's worked in the consumer area, and I've been looking to them of could we replicate their model in the political model, so that people are concerned sometimes that the Australian Electoral Commissioner doesn't want this responsibility, but could a independent board be set up underneath or separately to the commissioner that would essentially undertake the same role as what happens in the commercial sector, and that's something to be discussed, again, of how you enact it in practice. Ultimately, it comes back to the courts for determining a question of fact, but sometimes it's also about it's incomplete facts that are being put forward, right? It's the context in which those facts exist that's often missing from advertising. So, for example, what was fascinating after the referendum is both yes and no voters all came out saying they would like to see truth in political advertising, right? Voter protections, because they felt that the other side had lied about facts. And there are examples from both sides where I would say the facts presented were certainly incomplete, right? Or not put into context. And so you do then raise, I think, the credibility of the information put forward if you have the guardrails. So I think it can be done. And the legislation I've put forward is I think a sensible path. It can be tweaked. I'm totally open to that, but it is a process. I think it's just so needed. Without guardrails, we know access to information is one of the major pillars of liberal democracy, and your first step to an authoritarian regime is lost to lost to free access to information.
Yeah.
Picking up Zali's point there about incomplete information, because this is something that worries me. I'll give you an example on this. What we are seeing now, election campaign after election campaign, and it's happened just most recently in the ACT election, is you trawl through the social media history of opposing candidates and you find something really stupid or offensive or damaging that they've said in the past, and it comes out. They then come out and say, I've changed, it doesn't reflect who I am now, that sort of thing. I don't really know whether it is misleading to report their original statement without reporting their disavowal of it. They presumably would say, yes, it is. There's another point of view which says that the unfiltered expression of opinion when you didn't think you were being watched and you didn't know when you were being a candidate is actually a better reflection of who you are than your denials made at the demand of your campaign manager when you're in trouble. So to me, that's a real grey area of difficulty.
Presumably one that could be figured out over the course of, much case law potentially in this area.
Well, it could be, but I don't know. I think there's a fundamental question as to, again, where do the facts lie? If someone has said something which suggests that they're racist or anti-Semitic or the like, that goes to their basic character, and none of us can really read their minds and therefore know what the truth is in that sort of circumstance. So it's to me that's a real difficult sort of example. But it's the sort of example that I think is part and parcel of the environment in which we are now operating.
But I think the fact that come out of that would be a question of fact that would be incontrovertible would be, in the past that person did say or did do this thing.
Yeah.
What the meaning you can draw from that is not a question of fact. It's then a question of opinion. So the fact is they did say that. And then the question is, does that give rise to an inference in relation to that person's character or, position on an issue? And that then becomes a question of opinion as to, whether or not they have, moved on from that, disavowed it or not. So I think that it's thinking about what is the actual fact that you're saying is the fact in that instance. The fact isn't that, if someone said a racist statement, the fact isn't that they were racist in 2020 when they said blah, blah, blah. The fact is in 2020 they said this. The conclusion you draw from that is is different. So
Still up to people to make.
Anyway, I feel like we're splitting hairs, but that's okay.
But
Well,
there are no doubt so many
I
more.
raise that sort of thing because splitting hairs is what is going to have to be done.
Yeah. No, I don't disagree there. But I think, and again, but see, this is where if you think about the kind of advertising you could do with that, right? What you would say is the appropriate advertising would be in 2020, so-and-so said this. That is a fact because you've got a record of them saying it. You couldn't say so-and-so is X or is racist or is whatever. Because back in blah 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 they said that, like it's actually and so one advertising I think would be misleading and one would not be.
Yeah.
Well, I would sort of take issue with that because to say someone is racist because of something they said is an expression of your opinion.
Yeah.
As a statement and not necessarily factual one way or the other. So I'm not sure that would be prescribed.
I can imagine many, many years of figuring out the parameters of that. But if we can zoom out to end on, I guess, what we're talking about, which is the elevation of truth as a value, of it being a valuable thing in our society. I just wanted to get both of your reflections on how worried both of you are if we don't do this. I'm drawn to an Axios study happening ahead of a very contentious US election, where more than half of the respondents agreed with the statement, I've disengaged from politics because I can't tell what's true. Zali, how worried are you that if we don't do this, if we don't elevate truth, that it isn't just about social cohesion, it's about disengagement from politics, which then doubles down on all of those divisive effects that we have?
I'm always nervous about raising the word truth, like using truth, because just to digress a little bit, even back in the courts, you can get two witnesses can give an account of an event, and they can give quite different accounts of that event, and their truth of how they have experienced that event may well be truth to them, but a judge will interpret who is the most credible witness, who was maybe unimpacted by influences or other elements, and so whose version of facts is the credible facts that is accepted by the court as being the accepted facts in the case. So that's why I'm always really nervous about using truth, and that's why I've moved away from calling it truth in political advertising to being voter protections, to compare it to consumer, but also because I think truth becomes difficult. I think what we need to elevate our political discourse to credible and accepted facts, right? We can have opinions and people can have their versions, but we must have a basic set of facts. And I think that's what that quote you just gave us about people's disengagement with politics because they don't know what to believe. It comes down to, well, what facts can they believe around an issue or a policy or a concern? And so how then do you assess how to fix that and who's putting forward a legitimate policy to address that concern? And so I think that's why, and that's why I come back to my opening comment of people being fact resistant. There are certain players in the political space who are definitely fact resistant, and despite there being overwhelming evidence establishing certain facts, they will still propose an alternate version, right? And I think that is really dangerous because what you then have is voters making choices on misinformation, disinformation. They don't have the facts before them, and you are then, we have a risk that liberal democracy doesn't work if you are, if you're misinformed. I mean, the irony is you go to sort of authoritarian regimes where you have control of information and where you have propaganda, right? Propaganda to continue the misconception about facts so that people don't question the system and don't, rise up against a system that is oppressing or not really delivering. So I think democracy is always fragile, and is open to abuse, and that's why we constitutionally have separation of powers, right? We have a judiciary, we have the executive, you have the government, and we have a lot of protections in our system for information, for media. They benefit from a lot of protections for freedom of speech. If I look at defamation laws, exceptions to privacy laws are all for news and for media. I do have concerns that where our media is going now is not the kind of ethical fact reporting news that was intended to benefit from those protections. We have more and more media that is opinion, and should opinion be protected the way fact reporting in news is? I have a real question around the exceptions of public interest when it comes to defamation and privacy, where it's
another bill in the offing potentially.
Well, that's the review of the Privacy Act has been fascinating, and should we have a tort of privacy? Should news media have a benefit of an exception? There's a lot of questions around in our modern day. The concepts and protections we had in the past, should they still exist now? Are they still fit for purpose? I have a lot of questions around that. But there's no doubt that a health of a democracy is ensuring people that facts credible facts have to ultimately always get precedence, have to be protected, because if not, you get to propaganda and misinformation.
And Mike, would you agree with that?
To a significant extent, though, I think one has to be careful about drawing inferences from the US experience to Australia.
We're not as bad as that yet, is what you're saying?
Well, they have a sclerotic political system where people are locked into one of two parties, where a phenomenon like the independence is virtually impossible on scale in the USA. And increasingly what you're seeing is people choosing to believe what they want to believe. In those sorts of circumstances, disengagement from politics may well be a better thing than extreme partisanship, where everybody is sort of attached to one party or the other, and you have a problem.
Although you could argue that the disengagement leads to that.
Yeah, it's a chicken and egg argument in some ways, and that's part of the problem. I don't think we're in quite that sort of situation in Australia, simply because there are so many more alternatives. We also have compulsory voting, preferential voting, that makes it possible for a greater diversity of representation and proportional representation. I think the other point that's worth drawing from the US is the experience about trust in institutions. And this is where I come back to the issue of who should be the enforcers in any sort of regime of truth in advertising. Because one of the really scary things we're seeing in America now is basically people denouncing the electoral process if they don't like the way things are going. And we need to be careful, I think, in these sorts of reforms in making sure that in solving a problem in one area, we don't create a problem in another area. And that I think is why I completely agree with the Electoral Commissioner's point of view that the AEC should not be an enforcer or arbiter on these issues of truth. I suspect that the reason that it's been thought about in that context is a hope that the existing trust in the AEC would carry into its administration of truth provisions. My concern would be that the opposite would be the case. That in fact being involved in something as politically difficult as ruling on, and potentially controversial as ruling on the truth or otherwise of people's political statements, would be used by bad faith actors as a pretext simply to denounce our election administration.
But I think Zali and the other legislators are alive to this and are talking about attacking that, as you were talking about a sort of an independent board potentially that could be.
My view is it should be totally separate from the AEC, and then if you have, if it works, that's fine. You have a new institution that has proven itself. And if for some reason, because of the sort of reaction you get from bad faith actors, the whole thing crashes and burns, no greater damage has been done to the broader infrastructure of our democracy. So that would be my biggest concern, leaving aside the fact that the AEC really has no greater expertise in this to bring to bear than a new body would have, and in some ways would have less. So that's why I think there needs to be a rather creative approach to that. If you're going to have a regulator, and it's worth bearing in mind that in 1917 and in 1984 there was no specific role for a regulator as such beyond the power to seek injunctions under the Commonwealth Electoral Act. And frankly, I think it may well be better to have a situation where if a party or a candidate is genuinely aggrieved, they can go straight to court.
There are so many different things that will need to be resolved and discussed before the voter protection legislation comes up that you're talking about, Zali, is even considered, and whether the political will is there is another thing altogether. But we could talk about this forever, and we've run out of time, unfortunately. Thank you, Michael Maley and Zali Steggall, for your time.
Thank you.
Pleasure.
Thank you for listening to our podcast. For more episodes, check out our website at scanlaninstitute.org.au.